the All India Bar exam is just around the corner, and I know the pressure is on. We are cutting through all the noise to focus only on the most frequently asked, game-changing judgments that really form the backbone of Indian law. Let's get you ready for that exam. First up, let's talk about constitutional law. I'm talking about the powerful basic structure doctrine. Let's look at where it all began. So, it all started with this monumental case of Ananda Bharathi versus the state of Kerala. The Supreme Court's ruling here was a total game changer. They said, look, Parliament can amend the Constitution, fine, but it cannot touch its fundamental soul, its basic structure. What does that mean? It means things like judicial review, fundamental rights, and secularism are completely non-negotiable. Now, let's look at the evolution of Article 21, the right to life. It's a fantastic story. At first, in the A.K. Gopalan case, the court took a really narrow, literal view. But then came Maneka Gandhi, and everything changed. The court declared that any procedure that limits your life for liberty can't just be any old procedure. It has to be fair, just, and reasonable. This one ruling basically brought the whole idea of due process of law right into the heart of our system. And the doctrine just kept getting stronger from there. After Case of Anda, the court started adding more and more pillars to this foundation. In the Indira Gandhi case, they cemented judicial review as part of the basic structure. Then in Minerva Mills, they said the delicate balance between fundamental rights and directive principles, that's also core. And in S.R. Bommai, they made it absolutely clear, secularism is an unshakable part of India's constitutional identity, period. And this expansion of our rights has continued right into our own time. I mean, the Supreme Court just keeps breathing new life into the Constitution. You've got the Puttaswamy case, which famously declared our right to privacy is fundamental. Then Navtesh Singh Johar corrected a historic injustice by decriminalizing consensual same-sex relations. And of course, NALSA, which made sure that transgender persons are recognized as the third gender, with all the constitutional rights that come with it. Okay, let's pivot to our next critical section for the AIBE, criminal law. This is all about the rules of engagement, when the immense power of the state comes up against an individual's liberty. All right, here are two cases that you see pop up in exams all the time. First, K.M. Nanavati. Yes, that famous case that ultimately led to the end of jury trials in India. And second, Lalita Kumari, which made it crystal clear. If the police receive information about a cognizable offense, they must register an FIR. It's not optional, it's a mandatory duty. No ifs, ands, or buts. Now, D.K. Vasu versus West Bengal. This is a case every single law aspirant needs to know by heart. It established incredibly powerful safeguards against custodial violence. The court laid down mandatory guidelines, things like preparing a proper arrest memo, making sure the arrested person can tell a friend or relative, and guaranteeing their right to a lawyer. These are not just suggestions, they are direct commands to protect the rights of citizens. Two more really important rulings in criminal law. In Rameshwar, the Supreme Court held that a rape victim's testimony, if the court finds it believable, is enough on its own for a conviction. Corroboration isn't absolutely necessary. And then, much more recently, in Joseph Shine, the court struck down that archaic law on adultery, Section 497, calling it unconstitutional and discriminatory against women. All right, let's switch gears and talk about administrative law. This is really where the rubber meets the road, where the judiciary steps in to make sure the government and all its various bodies are acting fairly and, playing by the rules. So here we see a really stark contrast. First, you have ADM Jabalpur, often called the darkest chapter of the Supreme Court, where it made that infamous ruling that the right to life could be suspended during the emergency. But just a few years later, the court really redeemed itself with Hussainaria Khatun. This landmark case, India's very first PIL, established the right to a speedy trial and free legal aid as essential, non-negotiable parts of Article 21. This is a perfect example of the court's power to step in when there's a legislative vacuum. Long before the POSH Act ever existed, the Supreme Court in the Vishaka case laid down binding guidelines to deal with sexual harassment at the workplace. The court actually defined harassment, put a clear duty on employers to prevent it, and crucially, mandated the creation of internal complaints committees. These guidelines were the law of the land for years until Parliament finally acted. And on to our final big section, environmental law. This is a really fascinating area where the courts have creatively expanded the right to life to mean a right to a healthy life, which of course requires a clean environment. The oleum gas leak case, MC Mehta, is an absolute giant in environmental law. It gave us the principle of absolute liability. Basically, it says that if an enterprise is involved in a hazardous activity, it is absolutely liable for any harm caused. No excuses, no exceptions. Then, in Subhash Kumar, the court made it explicit. The right to enjoy pollution-free water and air is a fundamental part of the right to life under Article 21. Now, the Vellore Citizens case formally brought two golden principles into our environmental law. First, the polluter pays principle. It's simple, right? If you pollute the environment, you have to bear the cost of fixing it. And second, the precautionary principle. This means authorities have to act to prevent potential environmental harm, even if there isn't 100% scientific proof yet. It's basically the legal version of better safe than sorry when it comes to our planet. All right, deep breath. We are now entering the final rapid-fire round. This is a quick memory jog. I'm going to name a right, and you should have the landmark case pop into your head. Ready? Let's go. Okay, right against illegal detention, that's DK Basu. Protection against just being handcuffed as a routine, Prem Shankar. And the fundamental right to a speedy trial, that has to be Hussein Ara Khatun. You got this. Lock him in. Next up, the right to shelter, that's Chameli Singh. The ban on smoking in public places to protect everyone else, Murli S. Deora. And the state's duty to pay compensation when it violates fundamental rights, that would be Rudal Shah. And to finish our rapid-fire round, the right to free legal aid for those who can't afford it? H.A. Hoscott. The right to minimum wages as part of the right to life? That's the People's Union for Democratic Rights, or PUDR. And a woman's reproductive autonomy? Suchita Srivastava. So, there you have it, a whirlwind tour of the most critical cases for your IBE exam. Remember, these judgments aren't just answers to questions. They're the stories of how our rights and laws have been fought for and won over decades. They shaped our past, and they're going to shape our future. The very best of luck on your exam. Now go ace it.